us, but we want to be sure to give Sean as much time as possible to enlighten us about what's happening at the NLRB. So want to welcome everyone to the NLRB update. Before I introduce Sean, I wanted to just mention a couple of things that are happening with Virginia LERA. We're having another program on May the 8th at this same time, 1 o'clock, a virtual program on applying the ADA in the workplace. So that'll be a presentation by Nicole Porter at William & Mary, and it'll be really terrific. So I encourage you to sign up for that one as well. The other thing is that we have been working on and finally accomplished putting the current resolutions, school board resolutions and ordinances up on the Virginia LERA website. So take a look at that. You can go and see the ordinances and resolutions that have been enacted around the state. And we hope this will be helpful to folks. I want to thank Justin Keating, who's on the call here, for supervising Anna Phillips, and thank her as well, a student at University of Richmond that worked on getting this up on the website so that folks can see what's happening in other jurisdictions around the state. And now I want to, I'm not going to take any time to tell you Sean's impressive biography because it was on the website, and I know some folks have heard him here before, so I want to give him as much time as possible to talk. But of course, Sean is the Regional Director of Region 5 of the NLRB, which is the region that covers Virginia. And he's done several of these updates for us before, and they're always enlightening. So we're just going to go ahead and jump in and get started. And we're going to do this with, I'm going to ask Sean some questions and have him respond to those questions. And if you all have questions, feel free to either put them in the chat and I will monitor the chat, or to save them till the end. We'll save a little time at the end for you all to ask questions as well. So Sean, welcome. Can you get us started by telling us the recent case law developments that we ought to be aware of?
Absolutely. Thank you for the introduction, Ann, and thanks everybody for the invitation to be here. It's always a pleasure. For those of you who were present last year, when I do case law updates, I do try to keep it to the previous year. So I'm not going to be speaking about cases that are more than a year old. So the what I refer to as the big dog of CEMEX or ChemEx or CMEX, or the case that is pronounced 3 different ways, I was not planning on talking about that because that's more than a year. So I think in the previous year, there are really 5 noteworthy cases that warrant mentioning. The first one that I'll mention is Home Depot, and I'll reference the case name and then what I kind of put into like a box that you can kind of associate this case with. So Home Depot is very much, I think, a significant case in the board's explication of what constitutes protected concerted activity. As many of you probably know, a lot of the activity that is protected under the National Labor Relations Act does not necessarily have to be union activity. It's what we refer to in the region as PCA, protected concerted activity. And in Home Depot, the board ruled that an employer, Home Depot, unlawfully discharged an employee for refusing to remove their work apron, their orange work apron, where there was a hand-drawn BLM for Black Lives Matter on their apron. Other employees at this store had done the same. And Home Depot, I think, is an important case because it offers a window into the breadth of activity that might be considered protected concerted activity. Perhaps a little bit broader than what had been done in the past. So, but the board very much, I think, tied their decision to the facts of the case. facts like other employees had been doing this at the store. That the significant fact that there were documented prior concerns of employees raising aspects of racial discrimination in that particular workplace, as opposed to a more generalized extra to their workplace situation. So because of the connection with what was taking place in their specific workplace, this activity from this employee was viewed by the board as a logical outgrowth of the prior concerted activities about racial discrimination in that particular workplace. So Home Depot, I think a fairly substantial case in the board's analysis of what constitutes protected concerted activity. Next case that I want to touch about is a somewhat dry topic of consent orders. The case is called Metro Health. And again, what I would associate it with is the concept of consent orders. Now, these are rare, but the board in the Metro Health decision overruled a case involving UPMC, the large conglomerate of health organizations in and around Pennsylvania, and held that the board will no longer accept these consent orders. The consent order is basically where an administrative law judge takes a settlement offer from the respondent in that particular case over the objections of both the general counsel and the charging party. And what the board really did in Metro Health was define their own authority and the authority of ALJs to resolve these matters, and how it's not really within the exclusive purview of the ALJ to resolve those matters. The general counsel needs to be involved. Now, in the Metro Health decision, the board thankfully did indicate there continued to be authority of ALJs to accept settlements between a respondent and the general counsel and or the charging party, but it really re-emphasized the importance of both the general counsel as well as the charging party in those settlements. So no longer will the board accept a settlement that just is taken by the ALJ over the objections of both the general counsel and the charging party. This year was a pretty easy year in terms of associating major cases with major doctrinal. We'll be referencing. Starbucks case that came out this year that I think was particularly noteworthy was a case that involved predictions about unionization. And in this case, the board very much kind of refined a longstanding doctrine, which is referred to as TriCast. TriCast very much stood for the proposition about the legality of employer predictions of what would happen if employees chose to be unionized. The most common, I think, of these, what referred to as TriCast doctrine, was that employees would no longer have direct access to the employer. What the board did in Starbucks is reframe that analysis and indicated that the board will be analyzing all of these statements about the predictions of the effects of unionization from a different standard. What the board thankfully did was indicate how a statement could be lawful. So to be lawful, these employer predictions about the negative impacts of unionization, they would need to be carefully phrased on the basis of objective facts to convey the employer's belief of what the board referred to as demonstrably probable consequences, and here's the significant aspect, beyond its control. So if the prediction was something that was within the employer's control, that was a factor that would very much push those statements towards the aspect of being unlawfully coercive of employees' Section 7 rights. The important thing about the Starbucks case is the board did what it rarely does, is indicated that it would be applying this prospectively only. So cases that were pending at the time, the board would not be applying that new test to the analysis of those statements. I promise that wasn't the last major retail name that I'd be referencing. Next case I wanted to touch upon was Amazon.com services. And this was a really significant case in terms of the board mentioning and deciding that the quote unquote captive audience meetings, and I should have associated that Amazon.com services equals captive audience meetings. Those meetings the board held would be unlawful, that an employer violates Section 8A1 of the Act by requiring employees under threat of discipline or discharge to attend any meeting in which the employer expresses their interests or their views about unionization. Now, the board was specific in saying it does not have to be simply negative views or neutral views. The board is simply evaluating whether or not the employer was expressing its views on unionization. The board overruled Babcock and Wilcox. For practitioners, Babcock and Wilcox comes up in another number of circumstances in doctrinal aspects of law, but the captive audience meeting was one of them. What the board did in the Amazon.com services case was also indicate how an employer could, in the board's view, lawfully hold meetings to express its views about unionizations. One of the aspects was that the employees were provided reasonable advance notice of not only the meeting, but the subject of the meeting. 2, that the attendance was voluntary. 3, that there would be no adverse consequences to employees to not attend. And that 4, no attendance records of the meeting would be kept. Now, similar to Starbucks and its decision about predictions about unionization, the board in Amazon.com services indicated that it was applying this test prospectively only. So for cases pending at the time, the board would not be applying that test. Relatively quiet year at the board in terms of what I think were the major cases. The last one that I wanted to touch about in the past 12, 13 months or so was Endurance Environmental Solutions. And this was the case that came out, I think, chronologically last in terms of the board's major doctrinal cases of the past year. Endurance Environmental Solutions equals clear and unmistakable waiver. For the experienced practitioners among you, you know that the clear and unmistakable waiver is one of the footballs that gets punted back and forth every few years between clear and unmistakable waiver and contract coverage. And when I'm referencing these things, it's in terms of employer defenses to allegations of unlawful unilateral changes. So in Endurance Environmental Solutions, the board overruled MV Transportation, which had adopted a contract coverage standard for evaluating those employer contractual defenses, which is one of the defenses that's available to an employer, when there is an allegation of an unlawful unilateral change to employees' terms and conditions of employment. The last kind of major board activity from the past 12 months or so was the rule that went into effect in terms of the Fair Choice Employee Voice rules. 3 big aspects for these rules. One, and a lot of this was what is past is now prologue. For the experienced practitioners among you, what is current is I think likely to become past again in terms of pendulum swings. But in the Fair Choice Employee Voice rules, number 1, it restored the pre-2020 policy on blocking charges. That's where there's a pending representation case petition and also unfair labor practice charges that might potentially implicate employee free choice in casting their vote in that representation case that's pending. So once again, RDs like myself have authority to delay an election if a pending unfair labor practice charge would be considered sufficient to affect or interfere with employee free choice in election. Second aspect of the rules was returning to the pre-2020 rule for voluntary recognition for a period of time beginning in 2020. What would happen when there was voluntary recognition was there would be the opportunity for a petition to be filed despite the voluntary recognition of an employer of a union. And in that window of time, a petition could be filed in which there was no quote unquote voluntary recognition bar. That has been rescinded. So once again, there's no voluntary recognition bar is back in place, and there's no aspect of that window period for a petition to be filed. We always refer to these cases as Dana cases, going back, and this has been one of the footballs that gets punted back and forth. Easy for me to remember Dana. That's my wife's name. The last aspect of the rule change was in the construction industry, and some of you might be familiar with 8F and how you can convert that 8F collective bargaining relationship in the construction industry into a 9A, which is the standard collective bargaining relationship that covers some protections. The rules went back and restored some of the precedent that has existed in terms of Casale Industries, and how you can establish that voluntary recognition of a 9A, as well as the Stanton Fuels aspect of establishing a 9A relationship through contractual language in the 8F CBA that can establish a 9A relationship. So those, I think, were the major kind of case law and rule developments at the boards in the last 12 or 13 months or so.
Great, thanks, Sean. Not seeing any questions in the chat right now, so I'll move on to my next question, which is, what should we know about the new acting general counsel that was recently appointed, and any changes that might result from the appointment, termination of the prior general counsel and appointment of this new acting general counsel, and how might we see those changes playing out in the region?
Sure. I'll start with the easy part first. The easy part is the biographical information. For those of you who were not aware, not too long, but longer than I think a lot of us were anticipating after Inauguration Day, President Trump relieved General Counsel Jennifer Abruzzo of her duties by operation of the Federal Vacancies Reform Act. The Deputy General Counsel, at the time, Jessica Rutter, was elevated to acting general counsel. President Trump relieved her of her duties, and then appointed Bill Cowan as the acting general counsel. Bill is a longtime NLRB employee. He has been the regional director for one of the two LA-based regions since 2016. Prior to that, he was the solicitor of the board, and the solicitor of the board handles a number of the aspects in which the board is involved in litigation. One of the major aspects of the solicitor's job is evaluating 10J requests from the general counsel for injunctive relief. That's just one of many aspects of the solicitor's job. But they're very much in tune with a kind of a bridge between the general counsel side and the board side in terms of litigation. Bill Cowan was the solicitor for 10 years, 2006 to 2016. He was what was referred to as the special assistant to the chairman at the time. It's, I think, more appropriately named, which is now the chief of staff position. So Bill was very much involved in the inner workings of the board from 2002 to 2006, and prior to that, he was a board member, and prior to 2002, private practice and prior board experience. So he is very, very well versed in really all aspects of agency operations, and most recently, very well versed in regional operations. As is common with all general counsels, one of the first things that a new general counsel, and Bill's an acting general counsel, does is issue their memo rescinding previous memos. It's a lengthy list, and I do want to, mention just a couple of the prior memos that acting general counsel Cowan, his memo rescinded. So acting general counsel's memo, which is 2505, and this is all available on the agency's website, rescinded general counsel memo 2102, which was to go into the Wayback Machine in terms of January 2021, which is when Acting General Counsel Peter Orr rescinded certain General Counsel memos from the removed General Counsel Peter Robb. So it's a rescission of a rescission, and I think some of us review a rescission as somewhat of a resurrection, given the time of year we're in. But we have not received, there hasn't been any sort of additional public guidance about what to expect in terms of those General Counsel members. The rescission was rescinded. But I do think that it's fair to take a look at the pre-2021 memos as guidance for what is at least reasonably in play. I have no problem sharing that certainly in Region 5, we have taken a view of cases subject to deferral that is probably a little bit more consistent with what General Counsel Peter Robb expressed in memorandum. Just a couple of other the memos that were rescinded that I wanted to touch upon because they may affect your clients. One of them was GC 2108, which spoke of then General Counsel Abruzzo's views about the statutory rights of individuals who played sports for academic institutions. Quote unquote student athletes, which I believe the memo said referencing those individuals as student athletes might be an unfair labor practice by itself. That memo has been rescinded. So important, I think, consideration, if your client base includes such individuals or the academic institutions itself. Another aspect that I think is important to reference in terms of what was rescinded is some of General Counsel Abruzzo's memos regarding remedies. And I want to speak to that because I think that implicates what you can expect from the region. General Counsel Abruzzo had a memo in which a lot of creative initiatives regarding remedial aspects of cases were identified, such as regions should seek or insist upon in settlement agreements and in litigation before the board. Those memos have been rescinded. But that doesn't mean that some of the remedies that are referenced in those memos are not available to us. And I have no problem sharing internally in Region 5, we've already had discussions about whether or not, such as something like a notice reading remedy, we should still be seeking that. And my answer to those things as they come up is, if it would have been appropriate to seek a notice reading remedy before several administrations ago, it's still appropriate. And not to worry so much about what's in what memo and what memo has been rescinded, but to look to the longstanding board standards for seeking those enhanced remedies as to whether or not they're still appropriate. And as far as I'm concerned, if a remedy is something that has been available at the board in the past and the board has identified as something that's available for particular cases, such as an egregious case, that continues to be available, provided the kind of factual predicate for that remedy exists. So just a little bit about remedies. Some of the other memos that were rescinded, I think, spoke to GC initiatives that did not, come into fruition that the board granted imprimatur to, such as non-compete agreements, GC 2308. That memo was rescinded. And there were some other GC memos that I think fell into the same vein, such as GC 2501, which spoke to then General Counsel Abruzzo's view that certain, I believe what she referenced as stay or pay aspects, such as whether there was a training reimbursement requirement should an individual employee leave their employment, that those in her view were unlawful. That's been rescinded. So I think those are some of the major kind of rescissions that have existed. It's a lengthy list, but there were also another group of memos that were rescinded in which Acting General Counsel Cowan indicated regions would be receiving and the public would be receiving additional guidance on. And that goes into some of the other remedial aspects, some of the things of 10J, what we can look for when we're seeking injunctions, interagency coordination, how we handle ULP investigations, and CEMEX. I should have referenced before, all of the cases that I mentioned before were decided by a Democratic majority board. I don't think I'm telling tales out of school to say that, well, number one, right now we do not have a Democrat. We don't have a majority board of either party. There's only 2 members. But I think all of those cases are subject to revision and potential reversal once there is, as anticipated, a Republican majority board.
All right. Any questions at this point for Sean? I have a couple more questions, but if anybody has a burning question at this point, speak up.
I have a question.
Yeah.
Sure thing, just.
This might be a hard one to answer. On a day-to-day basis for the region, how would you say things have changed in terms of the work that you do when you interact with, labor and management? How has it changed in big ways since January 20th? Or maybe not at all, or you know what I mean?
Which January 20th are you referring to?
The most recent one? If you want, we can go back 4 years. We can talk about the big evolution.
Because it's, I think, I mean, January 20th, 2021 was an unprecedented event with the President Biden's removal of a GC. And then what you saw after that was, a really ambitious agenda. You've now seen, I think, the next thing in terms of January 20th, 2025, where you then see the president removing the general counsel, and you see a flurry of activity, in this case, the rescissions. But from a regional perspective, not that much has changed. And really the biggest things that have changed is basically checking the lists to see if, when a case comes in, to simply investigate it, to handle it exactly the way we would at any prior time. But while you're doing that, to be checking the list is like, well, is what's being alleged something that was a GC initiative that has now been rescinded? So, not to put kind of a percentage on things, a whole bunch of what we do is exactly the same. It's just that additional step of checking that list to see whether or not what's been presented is something that has been rescinded. So there's time that is involved in checking that list, because the lists are lengthy.
I have a question that's maybe a bit related to Justin's question, which is, has the region felt any impact on staffing? We've seen all the stuff in the media about layoffs or terminations of employees, and I was wondering if the region has felt any impact from that, or if you've seen any impact, for example, at NLRB headquarters, and if so, if you've seen any impact, or if that impact comes, that is, if there are these terminations, what might be the impact of that on case processing and litigation?
Yeah, I'll start with the region, and you deal with a question in the particular moment that you're in, but I think it's really useful to put it in a broader context. A lot of regions, myself included, have been understaffed for quite some time. And I certainly give credit to former General Counsel Abruzzo in directing a lot of resources in terms of agency hiring towards regional offices. I was the beneficiary of quite a bit of that. So in terms of what has taken place since January 20th, 2025, we have not seen really hardly any impact on our staff. And I am not aware of any sort of significant impacts that we're going to be seeing in the immediate future. So for those of you familiar with a regional office structure, the regional director is the head of the office. We have really 3 managers. We have a position whose title is assistant to the regional director. That individual has kind of managerial authority over investigations and representation cases. That position has been filled, and I've got a fantastic ARD. There's a regional attorney who has managerial authority over all litigation level. Again, that position has been filled for a few years, and again, an enormous amount of confidence in my RA. We've got an administrative officer who is, a tremendous resource for all the regional administrative officers around the country. I've got 3 supervisory field attorneys. Each of those supervisory field attorneys has a wealth of experience. I haven't worked with each one of them for many years, enormous amount of faith in each one of them. They've each got teams of approximately 6 professionals on each of their teams. We've only seen 2 departures from our professional complement since January of 2025, and one of them I would not ascribe in the slightest to a change in administration. It was look. I've got DC. I'm in DC right now, and for metropolises, they're the places that draw people from around the country when they're young, and then those people go back to where either they're from or where their spouse is from. So one of my losses was one of those individual who came into the great big city and then went to where his fiance was from. I did lose one field examiner to the fork, so to speak, the deferred resignation retirement program. So I think that there's been very little that's been affected my staff. Of course, that's subject to change, as everything is, but right now, we feel very, very good about in terms of where we are as a staff. In terms of headquarters overall, I'm not familiar with the overall component. I believe that the numbers for the agency total, I think this was reported in Bloomberg earlier this week or late last week, was 32 total in the NLRB that accepted for some sort of form of deferred resignation. So not that much of an impact so far. I do, if you don't mind, I do want to dial back in terms of referencing some of the things that were reported in the press that Acting General Counsel Cowan mentioned at the recent ABA conference, and one of those was a focus on bread and butter issues. And another comment that was reported in the press was focusing results, not headlines. And my view on that is that there's a view towards returning to what we do and frankly what we do exceptionally well in regional offices in terms of processing cases and not necessarily if we're not advancing a number of then General Counsel Abruzzo's initiatives, that enables us to focus on the quote unquote those bread and butter issues and hopefully see some productivity in terms of our case dispositions. One of the things that Acting General Counsel Cowan mentioned was boosting settlements. And I think that his view is that removing some of those GC memos about settlements and full remedies will enable for a more robust settlement discussion and depart from I think settlement discussions in which I think at least the charge party felt that it was capitulation, not settlement. Acting General Counsel has really, I think, publicly spoken about clearing the backlog. Regions have a substantial backlog of cases. For those of you who have cases before me as both charging party or charge party, I know it. If you have any sort of specific things, my telephone number is publicly available. You probably know it. Give me a call. If there's some sort of reason where we can kind of prioritize something, we certainly can try to do that. But all regions have been suffering from a backlog of cases. And I think it's an initiative of Acting GC Cowan for regions to focus on clearing that backlog.
Okay. I see hand Neil Pettit.
Yes, you talked about headlines. So I'll transition to my next question on a headline. I saw an article a few weeks back about Whole Foods objecting to the regional director's ability to certify an election victory by the union because of claiming a lack of quorum, functioning quorum. Have you had any of that in your region, or have you heard of any other cases, or is that just like a limited?
I have certainly heard that. I can't recall it coming up in a Region 5 case yet, but I am aware of the lack of a board quorum being brought up in Region 5 cases. My recollection is it's been brought up in a different context other than my issuance of a certification. My view is that the board has spoken on this, and as a board employee, I'm beholden to the board, and if and when that kind of argument comes up, a board employee such as myself is going to refer to the board's own rules and regs, which have delegated the authority to regional directors to continue to process those representation positions and issue certifications, even in the absence of a quorum. So that's what I'm going to continue to do. It's certainly an argument that an entity such as Whole Foods, I think CVS has also raised this argument, continuing the theme of great big retail names. It's an argument that they can make, and there's a forum for that. But from a board perspective, I think my determination as to what I will do in those situations is crystal clear.
Well, Neil, you anticipated my next question, which was about that impact of the absence of a quorum. And I guess just, the quorum issue has been settled by the Supreme Court with only 2 board members. The board itself can't act. So I guess then the question is sort of what delegated authority that affects, which is the question about the elections. I have not seen anything about any sort of appointment. And of course, there is litigation. Member Wilcox has filed a lawsuit challenging her termination because the statute says that board members can only be terminated for, I think it's malfeasance and neglect of duty. And it's not really clear.
Statute also speaks of a hearing as well.
Oh, okay. It's not clear what they're claiming. I thought it interesting that there were 2 Democratic board members and 1 Republican board member at the time this new administration took over. They only fired 1 of the Democratic board members, and both of them, I believe, had union backgrounds.
Yes.
And they fired the Black woman and not the white man. My comment. I don't expect you to comment on that one, but
I don't think that's a comment. I think that's a fact.
I found that interesting, and I don't know the explanation for that from the administration. But any other impacts you're seeing on from the absence of a quorum?
Well, the impacts that we're seeing, and to mention one additional element, oral argument was yesterday on Member Wilcox's, or should I say former Member Wilcox's lawsuit. What's being reported, I think in the trade press is that I think that the administration's arguments were met with some skepticism from the bench, but I don't think I'm telling tales out of school, and I think this was articulated by the judge in the case is whatever happens at the district court level is just the first salvo, and this issue, is on the expressway to the Supreme Court with this idea of the unified executive. In terms of effect, I think the biggest kind of practical effect that we see is for cases that we have pending at the board, we know that we are not likely to see any activity on those cases. because as you mentioned, as everybody knows, the board only has 2 members at this time. That is one short of the membership needed to have a quorum. So anything that is pending at the board, we know we're not going to be see any activity from. And that's certainly a frustration in terms of the individuals and entities that are involved in the litigation. And that justice is going to be continued to be delayed further. And of course, it's a common saying that justice delayed is justice denied. There was some court of comment in terms of, I think this was Chairman Kaplan was reported as saying that, there isn't any sort of expectation that there will be a new board member seated for at least 4 months, which is, an appreciable amount of time. Other than that, I really can't speak to any effect that the board's lack of quorum has had on us. One thing that I will mention in terms of how it might not have that much of an impact on us was another board delegation of authority. And another board delegation of authority were for such dispositive motions as a motion for default judgment, or a motion for summary judgment, or a motion for dismissal. And the board delegated its authorities for those matters to the Chief Administrative Law Judge, Robert Giannassi. And I think that's important to kind of consider when you have situations in which you're seeing motions for default judgment, such as if in a no answer situation, or where you're seeing the kind of classic test of cert motion for default judgment, where a respondent employer refuses to recognize and bargain with the union in order to test the legal validity of a certification issued by a regional director.
All right. I see a question in the chat from Emily. How many staff remain? I'm not sure if that question was about your office or the board in general. Is that a question? You've told us about some of the folks leaving.
Sure. In terms of the region, math was never my strongest suit. I've lost 2 people. One to a transfer or field examiner, another to the deferred resignation, also a field examiner. I should have mentioned this in terms of, my staff is one of the things that was frankly something that we had struggled with. Was we were very much down, short-staffed in terms of our administrative group of individuals, and our most recent hirings was really a heavy focus towards our administrative staff. So we brought on 4 additional administrative personnel in the probably the last quarter or so, November, 4 months or 3 months back, which really helps a lot. We were noticing it, and some of you may have noticed, you may have filed a charge on one day and not seen it docketed for at least a day afterwards. Like, you should be seeing, quicker turnarounds in terms of those administrative aspects of filing a charge and getting it docketed, et cetera, because we're back to where we should be in terms of our administrative staff.
That's great to hear. In terms of issuance of complaints under these decisions that came down under the previous board, what we might call the Biden board, is the practice then for you to continue to issue complaints if something would be a violation under that law, even though you anticipate perhaps a change in the law?
That would be my expectation. As I mentioned, unfortunately, one of the first things that you see from a new general counsel or acting general counsel is the rescission memo. Very oftentimes, the next thing you see from a general counsel or an acting general counsel is their list of mandatory submissions to the Division of Advice. And for those of you who are not familiar, the Division of Advice very much acts as what I would characterize as a think tank for whoever is in the office of the general counsel at the time. A number of the issues that are mandatory submissions to advice have never really changed for years. They are issues that rarely come up, and you really want, to have another group of eyes on them. A classic example of that is when there is, an arguable conflict between the NLRA and a state law. That's has been a mandatory submission of advice for as long as I've been with the board. But the biggest category is things where the general counsel is interested in exploring a reversal of precedent, a modification of precedent, or taking the law in a different direction. We have not seen a mandatory submission list from Acting General Counsel Cowan. So my intention is that if something is alleged to be unlawful under extant board law, is to find merit to those allegations and potentially to issue complaint if it can't get it settled.
All right, thanks. Other questions from you all out there in the audience? Feel free to speak up or raise your hand.
Fire away.
I'm assuming you don't know anything at this point about the budget going forward. I know the budget's been the same for a long time.
We actually got a little bit of a bump in the relatively recent past. So in terms of the agency budget, I have not heard anything. Based on the location of my house, I am literally a Beltway insider. So there was, I think, some gnashing of teeth and rending of garments over a potential shutdown. The appropriations lapses next Friday. But for those of us insiders who have gone through this, is like, oh, that's next week. That's an eternity away.
Yeah, it does often seem to get resolved at the last minute in some way. Often by a continuing resolution.
So yes. A lot can happen in a very short period of time where there's a will and a way.
Yep. All right. Any other questions from folks out there in the audience? All right. Well, I want to thank you, Sean, for once again enlightening us a little bit of a different time period and more discussion about other things other than cases at this point. But it's been very, very helpful, as usual, for us to hear about what's happening and what has happened and what's likely to happen. So very much appreciate your
Absolutely.
once again joining us. And just want to remind everyone again, we have another presentation coming up on the Americans with Disabilities Act. That's on May 8th, and encourage everyone to sign up for that. I do see another question in here. Let me just ask this one. How much of a difference will it make with arbitration cases with the new administration?
The only thing I think that I would comment in terms of the difference it will make with arbitration is the concept of deferral. And for those of you who are not familiar, this is the best way I think I would describe deferral. Let's say you have a charge that you file with my region or another one of the regions. If you're in Virginia, you might be also in Region 10, if you're in the kind of the southwestern part of Virginia. Let's say you file a charge with my office that alleges a violation of the act. And there is a grievance that is also pending that has been filed with the party's own collective bargaining agreement and their grievance and arbitration mechanism. we evaluate whether or not to defer our processing of a case to that private grievance and arbitration mechanism in your CBA. And it has become a political football in terms of when to defer, when not to defer, and the standards that we apply. So my opinion is, if past is prologue, is that we will see a more expansive view of what to defer and when we can defer under the current administration than we saw under the previous administration. Generally speaking, Democratic administrations are more restrictive in their view of when the NLRB and the general counsel side can and should defer to the parties' private grievance and arbitration system.
All right, thanks.
So it's who you get as an arbitrator, pretty much the same. Yes, no, we would not be involved in that.
Any other questions? All right, well, thank you, Sean.
My pleasure.
Thanks for everyone for attending. Encourage you to attend our next event in May, and also take a look at the website. Those of you who do public sector work, we have all of the resolutions and all of the ordinances posted up there on the website. And we hope that'll be a helpful resource for folks who are looking at what's happening in collective bargaining in the public sector in Virginia. So thanks so much, everyone, and look forward to seeing you all again soon.